Welcome to all our participants. My name is Abhijit Sangma, and I'm your host. We continue our journey through the Understanding Practical Bioethics series. In our previous session, we laid the foundational ethical groundwork for the end of life care. We discussed Johnson's four-box approach and clarified the vital distinction between withholding or withdrawing life support and the act of euthanasia. We learned that while the ethics are clear, aiming for dignity and reduction of futile suffering, the implementation often hits a wall when we encounter legal uncertainty. Today, in the second session, we are bridging that gap. We are moving from ethical why to the legal how. The Supreme Court of India recently allowing withdrawal of life support in specific cases, urging the union government for a formal law. Healthcare providers are standing on a shifting ground. So today's session, legal aspect of withdrawing, withholding life support, is designed to provide with the legal clarity needed to practice with confidence and compassion. So our moderator for this session is Dr. Ashita Singh. Dr. Ashita is a family physician at Chinchpara Christian Hospital, and she heads the palliative care program of Emmanuel Hospital Association. She holds MD in internal medicine from CMC Ludhiana and Masters in Bioethics from Trinity International University, Chicago, with specialized fellowships in infectious disease, palliative medicine. So Dr. Ashita is uniquely qualified to moderate this intersection of clinical reality and ethical necessity. And joining her today as our resource person is Advocate Siju Thomas. Advocate Siju serves as the National Director of ADF India, its Alliance Defending Freedom. He is an advocate specializing in constitutional and criminal law, having earned his LLB from the Faculty of Law, University of Delhi. He is also a fellow of the prestigious Blackstone program. Advocate Siju has been instrumental in providing critical legal assistance to the vulnerable and leads a strategic litigation team involved in some of the most sensitive cases before the Supreme Court of India. Advocate Siju, we are eager to hear your insights on the legalities of this tough decision. Now I hand over the floor to you and Dr. Ashita.
Thank you, Abhijit. It's lovely to be here on a platform like this and talk about these important things, right? Challenges and dilemmas that we face on a daily basis in clinical practice. And there's often a lot of uncertainty because we're not sure what is the right thing to do, what is the right way to do it. And we are very grateful that we have this opportunity to learn together and to also learn from experts in the field who will help us think through various aspects, especially the legal aspects of end-of-life care. So I'm not sure how many of us were there for the last session where we had a very vibrant and wonderful discussion on various ethical aspects of end-of-life care. And we talked about how it is possible to come to a decision about the appropriateness of withdrawing or withholding life support. However, we know that in practice, it is not as simple, and we often have doubts and fears about the legal protections and processes that are there to be followed for this. And in recent years, there's been a lot of progress in this field. So it's very nice that we have Advocate Siju with us to help us and to bring us up to date with what these processes are. So I think I will just invite you, Advocate Siju, to please help us. And if you can give us a gist of how this conversation about the legal processes for withdrawal and withholding life support have happened in the last few years, and where we are at the moment. What are the current provisions that are there and recommended processes for withdrawal of life supports in India.
Thank you, Dr. Ashita. Thank you for your kind words, Brother Abhijit. Thank you, Dr. Rupa, for having me here. Grateful for this opportunity to spend some time with a group of people, with a community who deeply care and also value, what they do. I think I mean that is what the Lord calls us to, in a way, through our professions, to bring our best in and to be also be constantly looking at how can we be providing greater care, greater attention to those that have been entrusted to us. I would take a few minutes to just quickly walk through what has been the legal development or jurisprudence on withdrawal and withholding of life support. And there are, I mean, it's a few decades of legal developments which I don't think will benefit us all a lot. I mean, if you would like, you can always, sit back for a conversation on that, on those lines as well. But I would think, if we only have so much bandwidth, what are those quick, important takeaways that really would summarize what is the legal position as far as withholding or withdrawal of life support is concerned? Then if we are able to gather that clearly, then I think I would have succeeded in my effort. I think if you want to start from anywhere, you should perhaps look at the most recent judgment. It is extremely well written. It is timely. And yeah, it's maybe a little more than 300 pages. It makes for a very light reading. But it captures the advance of law quite really well. And not just in India, it compares other jurisdictions also, which have dealt with similar concerns, similar dilemmas, and how they have responded to each and every aspect or nuance of that problem. So I really mean it when I say that if you are able to lay your hands on that judgment, then I would highly recommend that you all read. I'm happy to share a PDF link to it if you would like. It's a very accessible, clearly well-written judgment. So there are many things that the court, in fact, clarifies, and very few things that it is setting afresh. I think why the judgment is important, and what I'm referring to is the Harish Rana judgment, if you haven't caught it already. Why the judgment is important is for the clarity that it creates. And it's not saying a lot of new things, but it is streamlining the things that are already existing, clarifying, some of the ambiguities, some of the confusion that exists on this issue, and providing a pathway of how the medical professionals or people involved in this field are can take decisions when they are confronted with these sort of scenarios. I'm going to be referencing my note, but I'm going to just take you through. If you have your notepads or an opportunity for where you can take your notes, then I would highly recommend that you do that. So the central question that the court had to decide in Harish Rana's matter was whether, if at all, there is any legal basis for medical treatment to be withdrawn or withheld. That's one aspect. If so, then when can it be done? What is the juncture at which you take that decision? And then and what is the legal basis? Is it operating in a vacuum? Is it something that is dependent on the discretion of a certain professional or a certain set of people only? What is the clearly discernible legal basis on which such medical treatment can be withdrawn or withheld? So one of the things that the judgment does, and And right at the outset itself, it talks a little bit about what active euthanasia is and what passive euthanasia is. And there is some confusion, regarding the latter term, which I'll be sharing about a little bit in detail as well. So, very simplistically, it is trying to say that, when there is, a new or an external agency, or some way in which a harm is introduced, that disrupts life in the natural progression of life in some way. And it termed the expression there as something that causes death. That is what active euthanasia is. And then passive is something where it involves the withdrawal or withholding of medical treatment, essentially what we are discussing just now. So in a way, again, if the expression can be so coined, it says it is allowing a death to occur. There is already an underlying fatal condition, and you are withdrawing a certain intervention so that you're permitting the life, the trajectory of life to resume its natural course. Now, one of the first things that, or very important things that the judgment does, is that it tries to clarify that in the past, when the Supreme Court, in two of the most important judgments on the issue, which are, cumulatively known as the common cause judgments, or cumulatively known as just the common cause guidelines. This was and these were issued by the Constitution Bench of the Supreme Court. There's essentially 5 judges or more. So the first one was in 2018, and then there was a clarification later, a few years later, when some of the things were not very clear. So the court said that, even when the Supreme Court was referring to the concept or the idea of passive euthanasia, it was actually using it with the idea of withholding or withdrawal of medical treatment in mind. It was using it as a synonymous term. But it said it is very clear that it's an obsolete term, it's a rather confusing term, so therefore it should not be used. And in fact, midway through the judgment, it stops using that term, and it says that for all practical purposes, we should only be referring to euthanasia as that where there is active euthanasia, which continues to be impermissible in our country. It is not allowed under the constitutional scheme unless the legislature comes up with something. And there are countries which do allow it, but under our scheme just now, it's not there. And the second that we know as passive euthanasia, or that the court had been referencing as passive euthanasia till now, will be spelled out for what it is, that it is withdrawing or withholding of medical treatment. Now, the court, again stresses on the aspect, of how even this withdrawal or withholding of medical treatment as a matter of fundamental right came to be available to the citizens of the country. And this is, something that it develops from Article 21 of the Constitution, where the right to life is defined. And the court is saying that the right, and this has been the jurisprudence over all these decades, that the right to live with dignity under Article 21, as a corollary or as an extension of it, also includes the right to die with dignity as well. And here it makes the distinction between two kinds of patients, essentially. One who have the capacity to decide whether it is the right juncture, or take that call that now I need to die with dignity. So those are those competent patients. And then there are those who are incompetent, who cannot take the decision from themselves because they do not have that capacity because of their medical condition. So the idea that somebody has the competency to decide this is again rooted in the understanding of what are your rights under, again, it can be as part of your first principle. It predates the Constitution. So it deals with as part of my own privacy, autonomy, and the right to self-determination. If I have the capacity to decide that I deserve to die with dignity, I should not be subjected to this futile intervention or futile medical treatment, then that person should be allowed the right to exercise his choice. There are certain parts of that judgment which are slightly problematic when you try and apply that lens to certain beginning of life scenarios. But then still, on this, I mean, the court goes on to say that, nor the state nor any outside entity can interfere in a patient's right, a competent patient's right to decide on this aspect if he wants to take a call on whether he or she wants to withhold or withdrawal medical treatment, have medical treatment withdrawn. Now, in the case of incompetent patients, the court is laying down some specific conditions or medical parameters. It does not apply in all cases, and all these three have to simultaneously apply it to be permitted for withholding or withdrawal of medical treatment. So the first thing that the court says is that the patient must be diagnosed with or should suffer from a medical ailment which should be classified as terminal illness, should be in a permanent vegetative state or similar conditions. Second thing, the medical condition requires that you have been undergoing a very prolonged medical treatment as far as that ailment is concerned, and whatever treatment you are being given, intervention you are being given, it ceases to be temporary. I mean, you just need to keep continuing it up, to no end, and that through that is connected the third aspect, which the court says that this ailment must be something that is irreversible. I mean, irrespective of the treatment that you're giving, it just won't reverse. So the condition is incurable and there is no hope. I mean, you're not seeing any light at the end of the tunnel that the patient will get cured. It's in such parameters that in the case of an incompetent patient, that you can even consider withdrawal or withholding of medical treatment. And there also there are other prerequisites as well. But right now we are just describing what kind of, what would be the qualification or eligibility of a patient to be even considered for something like this. One of the other things very important that the court clarifies, and that applies to the medical fraternity a lot, and it says that withdrawal or withholding of medical treatment, when it is being carried out in the patient's best interest, it would not constitute a breach of the doctor's duty of care. It is very much in alignment with what a doctor is expected to do. The medical understanding of or the legal understanding of what the duty to care is, it does not include an obligation to continue treatment ad infinitum, that you just keep continuing it when it is in the best interest of the patient to dictate that you should withdraw or withhold support or treatment. Then taking such action is also a part of the doctor's duty of care, is what the court very clearly clarified. Now, the court lays down a twin test for any decision related to withdrawal or withholding of medical treatment. It's to be taken in cases of incompetent persons, people who cannot give consent or decide on it by themselves. It says two things have to happen. First, and it applies to that instant case also, Harish Rana's case also. The first thing that the court says is that whatever intervention that you are providing that individual must first qualify as a medical treatment. There must be something that can be defined as such, that it is being clinically administered. It may be at home also. It may be following certain parameters, but it is I can share a little bit on that a little later as well, because we have a lot of scenarios where people take discharges and would go back home. So what constitutes as medical treatment is also something that the court spent a lot of time on. But first, it is important that for the decision to withdraw or withhold medical treatment, first there has to be something which can qualify as medical treatment, and second, the decision has to be strictly in the patient's best interest. How do you define medical treatment? How do you define best interest is what the court spends the next bit of the time on, and we can spend time on it if you would like. But if I can, just quickly share how the court streamlined some of the things starting all the way from Gyankor, then, these are all judgments of the Supreme Court, then Aruna Schonberg's matter, and then the common cause cases that came about. It streamlined many things that have developed over many, many decades. And it just lays down some very important guidelines, some 4 or 5 important points which are fleshed out in much detail, but that's something that I'm leaving for your benefit just now in a summary. Is one, when in cases that involve terminally incompetent patients, the role of the patient's next of kin, friend, guardian becomes very important. Their written consent, as far as possible, the patient's own wishes, had he possessed that decision-making capacity, if there is an AMD, that an advanced medical directive that exists, that is the first step that you need to cross. Is there the right kind of consent, either the patient's or somebody, who can vouch for the patient. The second is, the court is saying that even if the medical care is being predominantly given at home, anybody who's responsible, the next of kin, friend, guardian, or someone, can admit that patient to the hospital of their choice or approach a hospital also with a limited purpose that, there be a primary physician be designated who will ensure that many of the steps that are involved in setting up the boards that are required, setting essentially the legal process that is required, can put those things in for a decision to be taken on withdrawal and withholding of medical treatment, that it can be put in motion. So there's a doctor who would trigger this process. So it can be, if it's in the hospital, then a doctor is already there. If it's at it envisages a situation, if you're at a home also, you could approach a hospital with this request specifically as well, that you trigger the process so that the legal guidelines can be complied with for such a decision to be taken. One of the things that the court is saying, that there are often delays in these medical boards being constituted, so it is putting timelines in it. It is saying, once a hospital raises a request, those boards have to be constituted within 48 hours and decisions have to be taken. And immediately it is saying that if it is not done within a time bound manner, then there is a remedy that you should exercise of immediately approaching the High Court of the particular state that you are in. There is that remedy also, that the medical boards have not applied their mind, or the hospital has not initiated the request at the right time, and therefore you have that remedy of approaching the court and asking the court to expedite the process. One other thing that it is saying is that once any decision has been taken on this by a medical board and now it needs to be implemented, there needs to be a 30-day cooling off period, where any person who has any challenge or grievance related to that decision can approach the court and challenge any of the opinions of the concerned medical boards. The magistrate, the person the judicial magistrate of that concerned area is supposed to be informed every time a board takes this decision. So there are certain guidelines that have been laid in place for how they will be vigilant to such sort of requests that would be coming from the concerned medical boards as well. But one very important thing, that the court again clarified, that for a very long period of time, there is an absence of a comprehensive law or legislation on end of life care situations. And which has meant that every now and then, whenever somebody has approached the court has had to fill that vacuum. Based on the direction that the court has given, the government has from every now and then issued certain guidelines, certain documents explaining the processes have been put out, but that does not substitute a law or a legal framework, which is essentially within the domain of the parliament, and there is an absence, and therefore the court is filling that vacuum. So, and this is the court is saying that this is not an institutional choice. This is not something that the Supreme Court wants to do, but it has been put in a situation. And for the longest period, there have been law commission reports, many sort of recommendations that have been made. But for whatever reason, the parliament or any of the state assemblies at a state level have not put down a comprehensive statutory framework governing all these aspects. I'll just stop for now. I know Dr. Ashita may have some follow-up questions, and I know some of you would have also had, perhaps, I have already touched certain things that you have had. But yeah, I'm happy to share more on just the things that I touched. But this is where things stand as far as this important judgment is concerned. And, in terms of its practical application, it would be yet to be seen if the timelines that are prescribed, if the bodies that have been made responsible to implement and execute many of the directions that are given are prompt enough to be able to make this a process which is the least cumbersome as possible. In my conversation with Dr. Ashita, what I understood is that people just generally don't probably want to go for something like this because just the way the process is, it is counterproductive. I mean, it is yet to be seen if it will pan out the way the one thing that has happened is court has addressed this lack of, this ambiguity, lack of clarity on the process, the timelines, and how patients, their families, their caregivers, and doctors, the medical fraternity themselves are all stuck in their all stakeholders concerned are stuck in their respective places without lack of clarity. So in that sense, it has clarified a lot of things. But yeah, we'll have to see how seamless or how smooth the actual process is.
Yeah, thank you so much for that overview, Advocate Siju. I think it's very important. Some of the things that you mentioned that the courts have recognized. First of all, that as medical practitioners, as healthcare providers, we are not obligated to continue or provide all available treatments simply because they are available, So that's an important observation. And also that decisions to withdraw or withhold treatment are also our responsibility in caring for people. Sometimes, the temptation is to say that, okay, this is too difficult for us to say. We only know how to provide treatment. We don't know how to withhold it. We only know how to advise that a certain treatment be taken. But it's also within our responsibility to help families and to actually make recommendations regarding withdrawing and withholding treatment. So thank you for that. And I think it'll be worth our while to actually read those judgments so that we can understand the nuances of the thoughts that have gone behind these judgments that have been made. Yeah. So I think one of the things that many of us in clinical practice, face or would like to be more better informed about is how exactly is that stepwise process that has been recommended, and what are the steps recommended and what are the requirements, and how should we go about if there is, for example, a patient in my ICU today who is, who we believe is at a point where any further maintenance or continuation of life supports is likely to be very futile. So what are the steps and what are the ways in which we can approach this?
Yeah. For patients who are, incompetent, for whom a decision needs to be taken, whether, this is the right juncture at which the that medical treatment needs to be withdrawn or not, or withheld or not. The court envisages both scenarios. One where an advanced medical directive and therefore some set of guidelines or directions exist, and the other where it doesn't exist, and in that situation also what needs to be done. So probably I'll walk you through first the scenario where such a directive exists. How that is created is something probably we can, after this probably we can take it up, or maybe I could just immediately start with that, as long as you don't lose your chain of thought. I mean, we want to come back to the idea, in a scenario where there's an advanced directive, what do you do? And in a scenario where it is not, then what do you do? But it would be good to understand how advanced directive is to be made also, or certain questions that the court asks is who can execute an advanced directive, who can make one. So first it says that it has to be an adult who is of sound and healthy mind, who is in a position to communicate, understands, has right comprehension, and would know the consequences of executing a document of this kind. It has to be voluntarily made. There shouldn't be any coercion, inducement, compulsion, when such a document is being put together. The always the standard is that of informed consent. It should be something that a person has enough understanding about the consequences, or has already considered all the pros and cons before preparing a document of that kind. Now, one of the things that the court asks when you are putting together a document of this kind is that it needs to be in writing for sure, but it has to clearly state as to when medical treatment may be withdrawn. When would it trigger? That document has to have that sort of clarity. Many times I understand these documents are quite vaguely worded as well. So court here is saying it has to be clearly put in writing as to when medical treatment may be withdrawn, when is that trigger point, or no specific medical treatment would be given, and what is the outcome, that I mean the either the withdrawal or the withholding of it should have the effect of only delaying the, I mean, if it was given, it would only have delayed the process of death, which otherwise was the natural trajectory in which how that patient's condition was progressing. So it is to put him out of that state of indignity. So to remind again, active euthanasia or just euthanasia is not permitted in the country. So nobody can put together a directive saying that which essentially is a suicide note couched in the language of a directive. So it has to be that it's at a certain, I mean, all those parameters that are the medical condition of a patient that I talked about, that would apply for even these processes to kick in place, would have to apply in the directive as well. That it is only elongating the process. It is not that it is not critical treatment, it is therapeutic only, and it's to no end. The second thing that the court says, there are certain things that the directive should specifically contain. Um, I think in a way it repeats this, why is this decision related to the, circumstances in which the withdrawal or withholding of the medical treatment is to be done. It has to be clearly indicated. It has to be in specific terms. The instructions have to be very unambiguous. And there needs to be a very clear revocation clause, saying that, at any point of time that individual so wishes, then they could always take back what they have said. I mean, in that sense, this document is very similar to how people execute wills. So that is why these are also in a way called as living wills. So what I willed at a certain point of time, in a certain frame of mind, may be drastically different, maybe 5 years down the line. So an opportunity to able to withdraw or revoke what I would have felt at that point of time should always be there. It should clearly specify the name of the guardian or the close relative who you are deputing or designating to be the executor of the directive, in case you are not yourself in the position to give consent, or you cannot, you don't have the capacity to be able to do that. It also envisages where there can be, like, just like wills, there can be more than one directive. You made each, at a certain point of time. So then the court says that the most recently signed one will be the last, or the most, or the only expression of the patient's wishes, and that is the one that will be given effect to. There are detailed guidelines as to how these are to be recorded and preserved as well. It has to be, I mean, it has earlier it used to be before a JMFC, a judicial magistrate, but now it has been made a little more easier. It has to be in the presence of two independent witnesses who will attest, and that has to be attested by a notary or a gazetted officer. They have to make sure that this document has been executed voluntarily. It's not with any coercion, inducement, and there's a full understanding. A copy of that document, once it has been executed, once it has been attested and all that, has to be given to the person who has been designated in it to be your, in a way, your nominee, your designated person to put it in effect in case you don't have the capacity, and also a copy to the family physician if you have one. A copy of it is to be also given to your local competent officer in the local government, municipality, panchayat, and the court has asked the governments concerned. In fact, notices have been issued across the country through this judgment saying that such competent officers may be appointed. I mean, I'm not sure when the judgment will reach and, when across the country such officers will be appointed. But apart from the designated person, apart from the family physician, that there be a government functionary as well who's informed about this directive is one thing that the court has kept in mind. So a copy has to be given. If you can't find one, then you have to address it to the local municipality, asking it to be directed to the competent person to be able to hold it. And the court is also looking at, now with all the digital health records being there, if there is a way to upload your directive there, then it should be part of your digital health records as well. Now, there are lots of aspects about how, when it can be withdrawn, when it can be revoked. But one thing it clarifies again that I mean, in fact, it categorizes patients in whenever it comes to these sort of situations in three categories, which in a way is what I'm coming to now. That a person is competent and can take an informed decision. He's incompetent, can't take a decision, but already has a valid medical directive in place, advanced directive in place, which has safeguards which can be followed. And the third scenario, where the person is incompetent and also there is no AMD that exists which can be executed. So what do you do in such situations? So we're just back to what, in a way, Dr. Ashita started off with. So please bear in mind the medical condition of such a patient that will continue to apply. That is like a prerequisite or an assumption to be followed, but I'm just repeating it again. It should be, that person should have a medical ailment which is seen as a terminal illness. It should be in a person should be in a permanent vegetative state. The medical treatment should be one that is too prolonged, and the intervention is of no effect. The condition is in a way incurable, and we don't really anticipate any change. Now one exception that the court is giving here, that that it has to be you have to make sure that all three conditions have to be met each time. For it, and it gives the example, that perhaps there is a directive which says that no treatment should be given in the event of a heart attack. Now, if this person is taken to a hospital and he has suffered a heart attack, his instructions cannot be given effect to, because first these three conditions have to be met, again met. Is he terminally ill? Is he in a vegetative state? Is this a prolonged medical treatment, and therefore that decision is being taken. So that parameters on which, when it will even apply, that would always, even override what are the directions that are there in the instructions that are there in the Advanced Medical Directive itself. Now this is the scenario that we will follow through for a situation where there is where there is an AMD that exists, there is a medical directive in place. Now, if a person is terminally ill and is undergoing a certain treatment, first and foremost, you have to make sure that the authenticity or genuineness of that document has to be verified. And the doctors, it all starts with the doctor who who's essentially looking after that patient. So due weightage has to be given to that document by the doctors. And when they are fully satisfied, this person is terminally ill, and it meets all those parameters, conditions that are in place, then whoever is the physician in charge has a duty to now actually act on what are the instructions that are given in the directive. The doctor, like I shared earlier, is that person who triggers the process. But the end, and in a way, I'm just responding to what Dr. Ashit also said. Where does the role of the doctor come in? The entire, all of the process is not entirely on you. But your opinion matters because you start it off or you set it off, but then you have to give your opinion to the hospital. The hospital will, in consultation with the next of kin or the designated authority, designated person in the directive, in consultation, keeping the best interest of the patient in mind, constitute a primary medical board. Now, this primary medical board has certain, these people who need, the physicians who need to be on it have certain parameters, qualifications that they should have. If the primary medical board, gives the opinion that that it is okay to, that they are of the opinion that medical treatment needs to be withdrawn, that is taken as the preliminary opinion, the first opinion on it. After that, a secondary medical board has to be constituted, where the CMO of the district is one, part of that forum of that board. And they also, they should then come and visit the hospital, the patient, and and again form their own opinion. All of this has to be done for each board within 48 hours. So these are the timelines that the court has really put in place. Now, if you're not happy with any of these decisions or findings of the concerned boards, there is always that opportunity for whoever is responsible for that patient to approach the concerned high court and revisit that finding and or express your concerns in any other way. If the things are progressing smoothly, the reports or findings or decisions of the primary and secondary medical board have to be informed to along with the advance directive, has to be passed on to the judicial magistrate first class in that region. That we are going to give effect to the decision to withdraw medical treatment. Now, in the cases where the AMD does not exist, almost all these processes would similarly follow. The only additional step that comes in is that now there is no directive in place to guide the doctor. That only in such condition that the directive becomes applicable. Now the onus falls on the doctor to see if it in the best interest of the patient, is this the medical opinion that you should be giving. So that is the only difference when an AMD does not exist. If there's an AMD, your opinion does matter, but the patient's opinion, which was put in writing when the person had the capacity to execute it, will take precedence. But if such a document does not exist, then based on your own finding, your own medical assessment, the doctor has the onus. The court is now putting an onus on the doctor, saying that is part of, and that's what I shared earlier. It is part of your duty of care to convey this. and again trigger and set the process in motion by asking the hospital and and then setting up the concerned boards, and then if there is no consensus, then approaching the High Court. If the opinions of the boards have taken finality, then informing the judicial magistrate of first class. Now, one of the important things again that the court adds as a process here is the whole idea of palliative care or end of life care. And it says that just because there is an opinion given or a board has given that that it be withdrawn or it be withheld, does not mean that the patient can be treated just the way any which way that you want. Or in a way, in all those scenarios where you take a leave against medical discharge and take the patient home and just leave that patient to their own affairs, that is not something that the court is asking or recommend. The court is saying that even there can be a treating physician who's looking at how the palliative care is progressing, and if the dignity that individual needs, even when it has been withdrawn, if that person if it's being extended to that person or not. When the court talked about it, it was actually envisaging those situations where somebody has been in hospital and the decision to withdraw or withhold the treatment has been taken in the hospital, and now you're taking somebody home. But again, like I shared earlier, probably you are taking this decision while providing such medical treatment at home itself. And the in Harish Rana's case, he was being fed, I'm not the expert on the medical terms that I use, a PEG tube. After a point of time, an informed layperson may have an understanding of how to administer and all of that. But still, just because it's being done at home does not mean that, it does not constitute medical treatment, is what the court is saying, because there are clinical requirements, how the nutrition is to be fed, what are the conditions. I mean, if again, how do you it can lead to CANH, how you administer the various things that are part of that hydration and nutrition process that you are providing. If they are not doing it properly, it can lead to complications. So medical care or medical supervision is a part of that process even at home, and therefore even if it's a decision that's been taken at home also, this process should be triggered, is what the court is saying. This in a nutshell is the process out there. Again, there are like I shared, there are timelines that have been placed. There have been people who have been deputed or made responsible to look at how these boards are being constituted in particular districts, in particular states, and essentially the administrative machinery of the government of various states or the government of India has to come into motion to actually initiate many of these things. But I'm assuming when you are confronted with some of these scenarios, you should use, I'm happy to share my notes from, all that I gathered from the judgment and what exactly the court is saying. I would assume that in many places, you would also be the first persons who are not just triggering for the boards to be set up, but also triggering that, the process for the bureaucratic support that is required from the government for these things to be initiated, for those also to be set in place. You may be the people who would have to initiate this in certain places as well. But otherwise, the guidelines are quite detailed and quite clear about where each stakeholder's role comes in, be it at home, be it in the hospital, be it as a designated or a nominated person to take a certain decision. In the absence of, or when the patient is incompetent to do that. And the court is saying the standard of care that all of us have to bear in mind is the best interest of the patient, and that again is quite flexible. The court has given certain parameters there, It's asking everyone to look at both medical and non-medical considerations as well. When you take a decision of that kind, medical would come easily to the doctor, but non-medical as well. Is this something that the patient would have liked, or would have the concept that it borrows actually from American courts or jurisprudence is the idea of substituted judgment. You are taking a call, in a way, a judgment, substituting yourself. You are not applying your own standards of how you would go about a certain decision, but you are putting yourself in that patient's shoes, and looking at all those non-medical considerations, and also to holistically come to and the court uses the word, it's almost like working on a balance sheet. So you will look at, these are the medical aspects, these are the non-medical aspects, and what is the, net at the gross at the end of it. Is this the call that you would take or give, keeping the best interest of the patient in mind? When all stakeholders together are able to agree, that is when such a decision of this kind has to be effectuated.
Thanks so much for that, for walking us through that. So just to summarize, in effect, what the courts are recommending is that every time a patient, the consideration of withdrawal of life supports is considered for a patient, there is this process to be followed. So if the person retains decision-making capacity, like you said, is competent and has capacity to make that decision, the patient is the best person to to make that informed decision. And of course, they must have all the information that they need in order to make a choice that is in keeping with their values and wishes.
Yes.
So the triggering of this process that we've been talking about is only when decision-making capacity is lost.
Incompetency is there, correct.
So that is our prototype patient who we have in our ICUs, say on a ventilator or on some life-prolonging treatments.
Correct.
And in that case, then whereas earlier the requirements were much more cumbersome, where you needed to have 4 people on each board, and each of the people should have more than 20 years of experience in their particular fields, and also specified it should be neurologist, cardiologist, and specific specialties. Things have been reduced now, so that the primary medical board can be from the treating team of the hospital, and it requires only 8 qualified doctors who have a minimum of 5 years of experience in their particular fields. So that has become, something that is possible for everyone to apply. So a primary medical board can be constituted immediately, and it's also possible in certain situations to have a standing primary as well as a secondary medical board. And then earlier, the secondary medical board, it mandated that the district chief medical officer had to be one of the people who was a part of the secondary medical board. And again, it needed 3 others who had 20 years of experience. So, it was almost like it's a recipe for disaster not happening. Now that has also been made more reasonable, so that definitely the district chief medical officer needs to be involved in the process, but not necessarily personally. The chief medical officer can second somebody, can nominate somebody who is a registered medical practitioner, and that registered medical practitioner, seconded by the chief medical officer of the district, can be one of the doctors in the hospital as well. And in addition to that, there needs to be 2 other people, doctors with 5 years of experience. So in effect, what some states have also allowed is that you can have a standing secondary medical board, which the chief medical officer has given permission for one of the doctors in the hospital to be his nominee for the secondary medical board, so that if the decision needs to be taken, we actually don't even need to wait for the whole 48 hours. If all the doctors are available within the hospital, it is quite possible for us to provide this entire process within a very short time, constituting a primary medical board, and then having a decision, which is then passed on to the secondary medical board, which is also possible to have within the same hospital or easily accessible. And then these decisions can be carried out. And earlier it used to be mandated that there needs to be an approval from the magistrate. But now it's not an approval, it's simply a notification
Yeah,
because they
intimation.
want to have a little, there should be some accountability. So I think these are really good processes that have been put in place. And in fact, there are many centers around our country now since the guidelines have become more clear in 2024. And we'll share those documents with all our participants as well about how this process, needs to be convened. Many centers have very smooth processes now, which I think gives confidence to healthcare practitioners who are being called on to make such decisions. You're not alone in trying to make these decisions. There is a process. There is a group of people who are thinking about it together, and it can be done in a way that protects the autonomy of the patient, and also good judgment and wisdom to prevail when there's a group of people who are taking these decisions. And I also like very much that in the guidelines that the Ministry of Health and Family Welfare has put out, they have strongly recommended that there be an in-house clinical ethics committee in the hospital that will help to think through these, through these questions of whether withdrawal of life supports is a reasonable thing to consider in this patient, even before it goes to the medical boards. And as we were talking about, like you were saying, it's not just a purely medical decision when you're talking about withdrawal of life supports, but it's a very comprehensive assessment. And we were talking about one tool last time, that is the Johnson's 4-box approach, which looks at the medical indications and then the quality of life of the person before and after whatever intervention is being considered. And then the preferences of the patient. What did the person want? What were his thoughts and desires and values and conversations like? Even if there is no advanced medical directive in writing, there will definitely be some knowledge and wisdom about what the person was like. What did they want? So those are the patient preferences, and then any contextual issues. So I think contextual issues would include things like, are there some people who probably stand to gain financially or otherwise from this person's death, and therefore they're requesting the withdrawal of life supports? Are there any vested interests in the whole process? So looking at those contextual issues, and also financial issues. Very often finances are one major reason why withdrawal of life supports is often considered. So I think all in all, we are on a much better footing for this to happen in a wholesome and very a way that is a process that has enough accountability and yet is slowly losing the cumbersome nature that it had before. And I think it should encourage all of us to explore this, see how we can improve our documentation processes without the default of sometimes what happens is, we say, okay, we as treating physicians and medical teams believe that actually this treatment is futile, but because we don't have a way in which we can confidently hold that responsibility, it sometimes becomes something that we pass on to the family, and it becomes a discharge against medical advice. But I think that's a really heavy load to put on families. It is so much better when there is shared decision making, and that's another thing that comes out very beautifully in all these judgments, is that we are not just leaving the family to make a decision and giving them all the responsibility for that, but we are saying we are in this together, and we are thinking about what is the best thing for this person together, and we are making a shared decision. And so these processes are in place. And hopefully at the end of this session, we will also be sharing some resources which will help us to think about this process, and also in our respective institutions begin to constitute these documents, begin to think about who will be on our ethics committees, who will be, who can be asked to be on the primary medical board in the various departments in our hospital, and also maybe have conversations with our chief medical officers in the district to see if it is possible for them to nominate someone we can call on in the event that we have such a decision to be made, so that we can keep with these guidelines and the process can become more robust. Yeah. So thank you so much, Advocate Siju, for taking us through those very important and very enlightening conversations and giving us this insight and information. Abhijit, maybe we could see if there are any questions that are there, or any comments that anyone would like to make, or any concerns that you would like to raise.
Thank you so much, Advocate Siju and Rashida, for that enlightening session. Before we open the floor to our participants, I just wanted to ask Advocate Siju a question in terms of, in absence of a statute, what kind of documentation is most critical to protect the hospital and its staff from potential litigation when support is withdrawn?
I think, because that's a fantastic question, and that's why I made sure I mentioned it, that being a legislative framework being absent is problematic for scenarios when things don't go as planned. If things are all operating, everybody is on board together, families are all right, there are no aggrieved people, don't have any concerns, everything is smooth, then it's okay. But when it comes to certain, if it's a ball drop, there's certain lapses. How do you fix liabilities? And just the things that Dr. Ashit also mentioned, probably there is some foul play that comes to light much later. So there are all these, a court of law at no point of time would ever be able to, because that's not its job, can, envisage all those possible scenarios and, lay down that level of granular law in place. In case, somebody is found guilty of a certain foul play or violation, what is the punishment to be prescribed? It can be disproportionate also, no? What if, tomorrow a police comes and files a murder case against somebody? This happens in medical negligence matters, where, it is shown negligence of criminal negligence, or in certain cases amounting to murder also, in certain extreme cases. So how do you protect the medical professionals? So all stakeholders need to protect. So therefore, the law, first and foremost, the law. Because if the statute is there, no, it will prescribe the exact question that you asked. For each step of the process, there will be a model form in place. Just like, for many of the processes, an example is as a requirement under PCP NDT law. When you are administering a USG machine or, any of those diagnostic, things at a clinic or a place, there are certain prescribed statutory forms that you need to fill in. So similarly, for this also, each step of the process, when you would have reached out to the CMO with a request, there will be a certain form in place. When the CMO, appoints a certain, the secondary board, then, there will be a forwarding that happens. So, that should again be documented. I think the ideal is for that statute to come about. But the parliament and assemblies have their own, legislatures have their own priorities, so we don't know ever, at what point such a statute would come about. In the absence of that, what I think, as hospitals, institutions, medical professionals, that you need to bear in mind is there is no prescribed format, but make sure that you are putting everything in writing. You are documenting it from your end. The consultative process, record what each stakeholder opined on, and reduce it to writing, have everyone sign it together, putting their, either their thumb impression or, their signature. So that's a document that everybody has read, and then it is, stored in a certain way. So, if a thumb rule that I can request you to follow in the absence of there being any forms or documents, is that put as many steps of the process that are possible in writing. And that would safeguard you, because that, you will be able to show that you have tried to keep not only the letter, but the spirit of the directions that the court has given from time to time, that you have gone over and above and beyond, and in trying to comply with how best interests are to be determined, how at what stage does the patient's family get consulted, as far as administrative processes are concerned, if there are delays, are the delays attributable to you? Each step of the process, I would highly advise that you document it. It's just your own judgment and discernment at this point. I would say now you would put it in writing, but do document it.
Thank you so much for the clarity. And right now, the floor is open for all the participants here. If you have any questions, you can directly ask and unmute yourself and directly ask, or you can also post it in the chat box. Yes. Anyone?
Ashita, either we were too good or we have our guests who have dozed off. I would like to believe it's the former.
No, I think you covered it really well. I think all the aspects, all the questions, I think there were several questions that were there in the registration form, and most of that have been, I think all of that have been addressed in your discussion. So that's really good, and really thank you. So if there are no questions, so at least one last remark from both Siju and Ashita. One last remark.
Yeah, for me, this is not an ordinary area of practice, in the sense that, as a lawyer, these are not kind of cases that would come to me. As just out of curiosity, because this is part of my practice and work, you do follow how the law is evolving. These are things on which, we will be taught in law schools, because there would be ethical concerns. There would be, international jurisprudence being compared with how international law operates. How does India fare in it, and all of that. So it's with much interest that I see this and I have approached this. But just in preparing for the session today, I just found how incredibly complex it is in a country of our kind to execute, to put something in motion like this. And two judges in the Supreme Court will not be able to, bear all the variables in mind of what happens in a particular district, in a particular hospital. So I think a lot of the the workability, the success, or keeping the spirit of what we are trying to do here alive would really fall squarely on all of you all as doctors and people of the medical fraternity. When you do see that this is an extension, or this is a part of your profession, and as probably as believers, we go a step further, as part of your witness, then how you would approach it, and how you would attend to it, and how you are making a difference in the life of that patient, life of that family, that immediate ecosystem around them. A lot of the onus is on essentially the practitioner. So yeah, more power to you all to make this work.
Thank you so much.
Yeah, I
Ashita?
think I would say that Just as Advocate Siju was saying, we are people who feel very passionately about human dignity, as especially as Christian healthcare professionals. And it is that grounded in the fact that our patients and every person is created in the image of God, that we want to uphold their dignity, their autonomy, and uh, you know uh, give them the best possible care, particularly at the end of life. So I think from that viewpoint, we feel strongly about all these things. We feel strongly about euthanasia not being acceptable, and we also feel equally strongly about allowing natural death and preventing the medicalization of death, and reducing the burden of suffering that many of our countrymen go through towards the end of life, and how can we protect them from that needless, burdensome indignity and suffering by bringing to center stage these conversations about withdrawal of life support, not on a whim, but when it is really relevant and important. And also, being being part of the decision-making process rather than uh, leaving patients and families alone to make these difficult decisions. So I think that is something that these conversations are very helpful for us to think more effectively about. And I think also there was some questions that Abhijit had shared initially, that had some issues about whether how does this match with our faith and our belief in the dignity and value and preciousness of each human being. And so we had discussed this in our last webinar as well. But just review that, and to say that, while the idea of euthanasia is against what we believe in our Christian faith, because we do not have authority to take life intentionally, no matter how severe the suffering. And therefore, there is an answer to that suffering, which is in comfort care and palliative care that is available. How do we provide the care that people need at the end of life without exercising an authority over their life, which has not been given to us by God? Whereas being responsible with technology that is available and not being enslaved by technology, and just putting our patients into the hands of technology and allowing that to be the default, but making responsible decisions about where we are going to limit the use of that technology when it comes in the way of human dignity and when it worsens human suffering, and allowing natural death. So where the intent is not to cause death, but the intent is to reduce suffering and to promote human dignity and comfort. And there was also a question about what is the role of nurses. I think nurses play a very, very important role in this whole process, even though there are no nurses' signatures that are required on these medical boards. But I think that, what I have seen in my experience as a physician, by the bedside, by the side of a critically ill patient, maybe who's on a ventilator or on some life-prolonging treatment, that our nurses have very good insights, and they know a lot about the patient and the dynamics of the family and the situations. And also, they often have a lot of wisdom to offer on what would be appropriate, understanding all the principles and values and technicalities of this whole process for all our nurses extremely important, because they are an integral part of the treating team. And so having, providing insights, raising questions about withdrawal of life supports, I think it would be wonderful if all our nurses have these thoughts and would come up with, ideas while these decisions are being considered, about what would be the best thing to do for this particular patient, that is in keeping with their values and wishes, and which will uphold their dignity and provide them the comfort and quality of life and quality of death that all human beings deserve. So I think nurses have a very important role to play. Yeah.
Thank you, Ashita and Advocate Shiju. I think this has been incredibly practical session, and I'm sure the doubts for participants have been cleared. That's why there are no questions that have come. So as we conclude, I just want to remind everyone that our journey doesn't end here. While we have covered general ethics and legal landscape in our previous session and today's session, our next session will focus on specific and highly challenging clinical area. So join us for the session 3, which is the topic is ethical consideration for end of life care in neurological disease. So we are looking at a tentative date of 14th of May. So we'll keep you updated. So do register, do fill the form. Helps us to keep you updated. And thank you for all your commitment to ethical healthcare, and have a meaningful evening. This session is now concluded.